supposed to be an open industry standard with lots of participants from lots of companies to develop the Java specification. When Oracle took over, actually prior to that, when Sun was still involved directly, Apache withdrew from the Java community process over this exact same point. The notion that you take a specification and then impose licenses on it that prohibit the development and release of open source software is no longer acceptable in the software industry. So requiring compatibility is anathema to the open source rules. You cannot impose a compatibility requirement on open source software and have it be open source. You cannot.
Yeah.
So there isn't a fair use case out there like this one, for sure. I think that one of the things that will be interesting to see is how courts grapple with this. I think there's another point of view than the one that Annette just gave us about how fair use might be viewed in this situation. I think the commerciality of a use is something to be taken into account. But these days, whether the use is transformative is probably much more important than whether or not it's commercial. And I think that there's a reasonable argument that re-implementation of the Java APIs in the Android software is a transformative use within the meaning that the courts have given it. Under the Sega case, which we've mentioned before, which is a Ninth Circuit Court of Appeals case, the nature of the work is software, and software is functional, and that means that it has a thinner scope of protection from copyright law than other kinds of works. As to the amount taken, the courts lately have been saying that how much you take has to be reasonable in light of your purpose. And I think that, again, reasonable in light of your purpose is to re-implement the API so that people can write applications for it. How exactly the harm factor would play into this, I'm not sure. But what I can say is that there isn't a fair use case out there just like this one, so that it will break some new ground, whatever happens, if the issue goes back to the trial court again. It's also worth mentioning that when a jury heard this case a couple of years ago now, the jury was within one vote of saying that Google had made a fair use. So it's a plausible fair use case if the jury almost prevailed on that issue back at the time that the case was tried. So.
Yes, ma'am. One of the issues that I'm particularly concerned about, and I'm sure others share this concern, is events like this, APICon, our site, Programmable Web, many other sites, we're all racing towards a world that's based on certain best practices. What I mean by that is we all are together as a community recognizing that there are certain patterns emerging in terms of how APIs should be designed, made really easy to use for developers, taking all the friction out. You know, from one API to the next, it's going to be very predictable. Companies are building huge technologies that essentially bake these patterns into the technology in a way that the technology produces an API that will often be a repeat of the last API created. Does this just completely wipe out all of that work? If one pattern can be copyrighted, it can't be. It may not be, and the copyright holder chooses to protect that pattern. Well, then we can't repeat the production of that pattern, repeat our best practices, and then what ends up happening is we design APIs to work around the copyright. We end up at a place of friction that inhibits the growth of the industry and inhibits developer access to those APIs, frictionless access to those APIs. What do we do now?
I just like to say again, in W3C, when the HTML5 specification was written, they purposely chose a new way of writing specifications so that it was both code and spec simultaneously. And in fact,
And that was a deliberate choice because of these issues?
because of these issues, they want to make sure that when people implement it, they know how to implement. And the best way to describe how to implement is to implement. Which is why in ITF, for example, one of the things that they like to see is an open source implementation of their specification in order to at least prove that it can be done so that anyone else can write whatever they want. So the notion that you have a specification that can be written in an open source program is critical for specifications nowadays. I don't know of any standards organization that avoids open source implementations. And in order to be open source, you have to be able to fork it. You have to be able to implement it. And you cannot charge royalties for it. And so there's a conflict in the mind of at least one company about what their goals are.
How can you enforce the obligation not to charge royalties for it without copyright?
If those
There is no way to do
royalties are material to Oracle, I'd like to know that.
No, that's not, I'm responding just to your point. You can't, the fundamental definition of open source is you can't charge royalties for it. But
No,
without
that isn't
copyright-
what I said. That isn't what I said.
Oh, I misunderstood.
The person who develops the specification cannot charge royalties for the specification. Anyone who writes open source software can charge whatever they want. But once they give it away, or once they sell it, it's under an open source license. And that person can change it. So why did Apache withdraw from the Java community process? Not because we didn't want to implement exactly the specification. We want to. But because downstream, the open source community that uses our software, they must be free under the Apache license to do any damn thing they want. And that's the reason that the restrictions on an open standard that require the payment of royalties or a patent license or that contain encumbrances and restrictions on what kinds of applications you can write. For example, Sun saying you can't write applications for kiosks, which is one of the restrictions in their little license that they try to sell to people. Well, that's not a restriction that open source can live with. We just can't.
So standard setting is a different process. And normally when you have an official standard, you have license terms that go with that are different from something that is not an official standard.
Correct.
And the Java platform is not an official standard.
News to me. What in the hell is the Java community process?
Well, it is true though that Sun, and I'm sure Oracle they're sort of the host of the JCP, Java Community Process. But it's not a de jure standard along the lines of something that comes from W3C.
It's not ANSI, it's not NIST, it's not any of those things. Who cares? You know?
All right, so I want to, a lot of open source talk. Decisions have been made, let's say things go along and it ends up being copyrightable. There's a lot of people in this room who are reusing patterns like I just described, or maybe have their own pattern. Now they have to do something, or maybe they can wait because it's going to take a while to play out. But we have some choices here. We have, I want to give Mike, you might have been quiet the whole time, I want to give you an opportunity to talk about, it's been proposed by another company in the industry, Freescale, that we have an API Commons. It seems to me that probably the world doesn't need multiple commons regimes for different industries, that if we can serve the purposes of multiple industries through one commons regime, that would be great. First of all, is a commons applicable here? And is that commons Creative Commons?
Well, commons is generally applicable. Say once you create a commons, which is generally, a set of resources that there's shared access and responsibility for APIs, and programmable web also has a directory of APIs. Those are, I actually mentioned those in my different things around APIs as API metadata or API registries, etc. So those things are sort of separate from the terms under which APIs are available or what the default regimes are available for implementing APIs. But things that are central points for communities to look at, like directories, can help set the norms for community. And so to the extent that programmable web directory or the API Commons directory is encouraging a particular set of licenses for the different sorts of materials that can comprise an API, then that can be helpful or not. And can briefly review the options. And actually, the discussion of standards bodies actually is one. Actually submitting your API to a standard process is an option, and that will involve granting rights to other people to implement that specification. There's also lighter weight versions of that. The W3C now has a community group process where you can take advantage of the same kind of legal ordinances, but not actually go through the full W3C process. It's very easy to start up. Another lightweight one is Open Web Foundation that Larry's involved in, and he can, that also kind of allows you to obtain a standards-like process, but without all the traditional heavyweight. Then there are public licenses, open source and Creative Commons licenses, which are typically copyright first licenses and apply to individual programs and works, but you can apply them to things like specifications, reference implementations, etc. And in general, I would suggest using an open source license, actually not a Creative Commons license. Apache license is the most obvious one. It's a permissive license, doesn't impose any conditions other than copyright notice and patent grant. And that patent grant is actually quite important because copyright is not the only threats around implementing APIs. And that actually gets to, there are a bunch of kind of theoretical misunderstandings about open source that you really should, and that's been promulgating, that you really should not go away from this panel, but I don't think there's time to dismiss all of them, but just everything she said about open source is wrong. And then there's Creative Commons licenses, and I don't suggest using those. Creative Commons doesn't recommend using them for software, and although there can be a documentation component, it's easier to just use the same license for everything. Apache license is a good option. The reason for not recommending Creative Commons licenses for software are basically that they're not designed to be compatible with other open source software licenses, and if you want implementations, you want to be compatible with those licenses. They don't have patent grants, or one of them has an explicit patent exclusion, so there could be landmines downstream. And there's just a general understanding of using open source licenses for software-like stuff. So if you don't want to think about it at all, and you probably shouldn't, just use the Apache license.
So today, if the people in the room are most interested in protecting their interests moving forward, and for the time being, the court has ruled that APIs are essentially copyrightable, should everybody in this room be racing to protect their, if only for defensive reasons, to make sure that they don't get sued, should they be racing to copyright their APIs, put an open source license on them, and just get their legal house in order to ensure, again, mainly for defensive purposes, because I think a lot of people, a lot of the members of the API, economy, foreign law stakeholders, are not interested in copyrighting their APIs for offensive purposes. Should they act now and get something done?
Everybody in this room already is. I mean, so 2 weeks ago, when you asked me to participate in this panel, I went to Programmable Web. There's, you could look at the top APIs of the day, right? I clicked through on the first 10, and every single one of them had terms of use on their websites describing both their sites and their APIs as copyrightable subject matter in which they claimed an interest. Every single one of them.
I want to thank you, by the way. We were wondering who the source of all that traffic was.
Yeah, I know.
I think
So,
everyone does.
everyone does. Everybody's claiming whole phenomenon of no copyright here? Quite the opposite. If you just look how people are actually behaving in terms of the way they're labeling things.
But legally, putting a copyright notice on something doesn't prove much. It certainly isn't the end-all for a copyright case.
It's not necessary at all for protection for copyright anymore. The copyright either exists or it doesn't from the moment you
But
create it.
there's a conversation to be had internally about what this means and,
Yes.
what we have ready in the event that somebody comes and sues us or something like that.
Well, I hope you're not asking those of us who are attorneys up here to give legal advice to people without anyone, unless you give me a check.
Somebody had to make that disclaimer sooner or later.
Yeah. But no one here is going to give you permission to do anything other than to say, I will tell you what Apache is doing, for example, which is giving the middle finger to Oracle with respect to the Java community process.
Be careful there, that was going to get ripped open in a
I
minute.
encourage you to read the JCP formation documents to see what Java was intended to be. But in fact, we're proceeding. But with respect to implementing big projects in Java, quite frankly, Sun and Oracle have cut their nose to spite their face. There are a lot of people in Apache who are no longer using Java.
Can I get a question from you? We are flat out of time. Obviously this has been such a heated debate topic and it's hard to kind of turn it off. But I do want to get this question from Tyler right here.
Yes, so there's this concept called a clean room development where you recode to implement an API. And
Start again.
it's a concept called a clean room development where you recode to implement an API. And my question to the panel is, if the decision stands, do you think it's possible to still do that?
Everyone tell them?
So I think yes. I think that likelihood is that anyone who tries to extract interface information and then re-implement it is less likely to run a risk of being viewed as an infringer. And there are certainly cases where people have done clean rooms that are still valid precedents for re-implementation. So I think that that's still something to say is a good thing to do. I think that it's quite likely that even if this appellate court decision stands, that courts will distinguish the kind of clean room situation from the Oracle v. Google case. And the dicta, so one of the things that actually lawyers pay a lot of attention to is what's the holding, what's the dicta. And courts often say, when confronted with this statement and this statement and this statement from a decision, that's dicta. It means it's not really binding. And so I think that there's again, a lot of room for interpretation. I think one of the things that Annette said at the very beginning that I very much agree with, which is APIs are not all one thing, and so it's a very broad category. So I think it's a mistake, even if you think that the Court of Appeals was right in this particular instance, it doesn't mean that all APIs automatically, as protected by copyright law, as Judge O'Malley's decision made it seem like they are. And so, but I think the sort of the distinction between the specification and implementation is one that's going to continue to be important, so that even if a specification document might be copyright protectable, re-implementing the specification in code, I think is still going to either be a fair use or something that simply doesn't infringe the copyright.
Pam, thanks very much. I really want to thank everybody for coming up today. It could have turned into a slugfest. I think everybody kept their cool and it was a really well discussed topic. So thank you for coming out this early this morning to talk about this. And thank you for responding to my invitation so late in the process to coming out here on such short notice. Thank you very much. Please give. Time left for this to be figured out, so we'll keep an eye on the case and we'll be reporting on it on Programmable Web. We have another 2 more discussions taking place in this room and the next room. In this room, we're going to have API security conversations.